Good day everyone, I am Michael, the moderator for this webinar. I welcome everyone for today's webinar, which is Emailing, Texting and the Use of Personal Device by Healthcare Professionals, HIPAA and Privacy Myth versus Reality. It's a great pleasure for me to introduce our presenter for today, Mark R. Brangelman. Mark holds bachelor's and master's degree in philosophy from Emory University and a Juris Doctorate from the University of Kentucky. Mark is a frequent continuing education presenter including national organizations nationwide. Now I would like to hand over the floor to the speaker. Over to you, Mark.
Thank you very much, Michael, from Conference Panel. This is Emailing, Texting, and the Use of Personal Devices by Healthcare Professionals, HIPAA and Privacy Myths versus Reality for Conference Panel today. I say good afternoon to everybody here on the eastern side of the United States and good morning to everyone on Pacific time. This is Emailing, Texting, and the Use of Personal Devices by Healthcare Professionals and how HIPAA and other laws apply. So based on the content of the program, you will be able effectively to identify basics of HIPAA privacy, the use of electronic communications and HIPAA, some examples of state licensure laws governing protected health information. We will give some elements of privacy notices and communications practices between patients. We'll talk about texting, emailing, and the use of personal devices. We'll have a little bit of a bonus at the end, website confidentiality and privacy disclaimers for the healthcare professional. So the disclaimers for this program, I think it's important to know what we are and are not going to cover, what this does and does not cover. So we start with the basics of HIPAA privacy, federal right of privacy under the HIPAA laws. The basics of HIPAA requirements are that in April 2003, it was applied as a federal law to healthcare providers, protected health information for covered entities. So protected health information has a more legal definition here. Overview of HIPAA confidentiality, there's always patient consent. Healthcare professionals and their patients communicate among themselves and with each other. Confidentiality of electronic communications is an issue for all healthcare practitioners. Why use texting and email? About texting, it is done to coordinate with caregivers for hours and locations, sharing information about patients that families want. So the preferred communication for texting is for young people to do that. The use of social media. Cellular telephone ownership is generally like 95% in the United States, maybe more now. Text messages are open 99% of the time with nearly all within 3 minutes. How best can you use texting and email in healthcare? You need to identify and use a secure communications platform and patient portal that would govern messaging and texting. The communication platform should be HIPAA compliant. Many users prefer text and social media to phone calls. Any communication between healthcare providers or between healthcare providers and patients must be conducted in a HIPAA compliant way if the protected health information is shared or exchanged. But the HIPAA has privacy and security rules on standards for access control, standards for integrity, standards of transmission security. You have to secure the transmission and use encrypted emails or secure patient portals, which are themselves encrypted, which require a patient login and a security identification. What about texting? Texting can be an acceptable method of communication between patients and healthcare providers. The same data security rules and practices apply to texting. Texting can be such an acceptable method, but as a practical issue, when are you going to text you? How do you get their personal cell number? Remember, HIPAA does not apply to patients. HIPAA applies to covered entities. Use reasonable safeguards, and that has its own definition. Should patient communications be included in the medical record? So records of communication with the patient regarding care, treatment, and services. What about telepractice and how that should be included in the medical record, and how do you keep that confidential? Here's an example about telepractice and the medical record that says that you should use secure communications with clients, including encrypted text messages via email or secure websites, and not use personal identifying information in non-secure communications. So you can have an informed consent agreement that says, in some cases, you may be charged a prorated fee for other professional services. So some common sense suggestions for the employer: do apply these kind of policies about emailing, texting, and the use of personal devices. Do have the interdisciplinary team review your employment policies relating not only to confidentiality. From a publication called Law 360, patient's privacy suit over hospital workers' texts was revived on appeal. Trial court dismissed the hospital, but the Indiana Court of Appeals reversed and remanded the case to the trial court. The medical assistant's misconduct occurred while at work, on the job, sandwiched between other authorized job duties and functions. The opposite result. Hospitals trial win okayed and sued over workers' Facebook post. So an overview of HIPAA violations with an emphasis on licensure boards. With regard to website and privacy suggestions, put these kinds of things in your privacy notice. Your privacy notices and procedures should include informing the client about the limitation of technology, potential risks. Here is sample privacy notice. Top takeaways. Review the ways your staff is using cell phones that introduces risk to patients. Cover the essentials you need to include in your HIPAA policy concerning smartphone access. Cover additional takeaways about data sharing. We've talked about business associate agreements. We've talked about state licensure laws, professional codes of ethics. HIPAA privacy, the use of electronic communications, some state licensure laws examples, privacy notice examples, all about texting, email, and personal devices, with a bonus on website confidentiality and privacy disclaimers for the healthcare practitioner. These are some top takeaways that HIPAA is not new. Wow, I am ready to take a breather. Michael, back to you at International Headquarters of Conference Panel. Thank you very much, Michael, at International Headquarters. This has been a great and worthwhile use of our time. Please look for our coming webinars with Conference Panel, as well as our extensive library of topics that you can pick and choose. Thank you, Michael. Over and out. Back to you.
Thank you, Mark. So that does conclude the session for today. Thank you everyone for participating. You may all disconnect now. Have a great day ahead. Bye-bye.